So, imagine this. What if a jury didn't just sit there and decide guilt or innocence? What if, instead, they acted as a supreme investigative body, completely independent of the government? It's a pretty wild concept, right? Well, welcome to The Explainer. Today, we're taking a deep dive into a really specific alternate legal framework laid out in our source documents. We're going to unpack how these texts describe a system where power doesn't flow top-down from the state, but actually bubbles up right from the people themselves.
This is Grand Juries Explained. I'll be your guide for this documentary-style look into how these sources construct a totally different worldview centered around the grand jury. We're looking at this purely objectively, piecing together the history, the structure, and literally the immense powers these documents claim the grand jury holds. Now, I'm assuming you're already familiar with the basics, state assemblies, jural assemblies, and how a jural case generally moves through that specific system. So we're going to focus our lens squarely on the grand jury itself.
Okay, let's dive into this. Here's our 5-part roadmap for today. We'll cover the foundations of alternative law, forming jural assemblies, grand jury independence, investigations and precedents, and finally, trial juries and nullification.
Let's kick things off with Part 1, Foundations of Alternative Law.
To really grasp this framework, we have to look at the specific historical texts these sources claim establish this alternative legal reality. And wow, look at this timeline. We start all the way back in 1215 with the Magna Carta. Then we touch on the 1863 Libra Code, which deals with military and martial law jurisdictions. And then we jump straight into the 20th century with Supreme Court cases like Hale v. Henkel in 1906 and U.S. v. Williams in 1992. The sources essentially take these really disparate historical markers and weave them together to build a unified theory of lawful common law authority.
Let's zoom in on that foundation for a second. According to the provided documents, Article 61 of the 1215 Magna Carta is viewed as the enduring legal basis that actually grants people the authority to form grand juries today. The sources claim this ancient document is totally still in effect, acting kind of like a double-edged sword. You see, while it allowed the government to administer, it simultaneously enshrined the unalienable right of the people to assemble their own investigative bodies. So why does this matter to us right now? Because for these assemblies, the ultimate authority doesn't come from a modern constitution. No, it's rooted directly in an 800-year-old treaty.
Moving right along to Part 2, Forming Jural Assemblies.
Let's see how this actually builds into the physical structure of these assemblies and how grand juries are picked from within them. The sources define a jural assembly very, very specifically. It's a group of people acting in their unincorporated capacity to organize what they call land and soil jurisdiction courts. Now, in this ideology, it's absolutely crucial to note the distinction they make between people and persons. These courts are strictly for living people operating under common law, and they are completely separate from what the texts describe as the incorporated statutory courts meant for corporate persons. It's a really fascinating semantic split.
Which brings us to a huge question. Within this highly specific framework, who actually gets to sit on a grand jury? How are they selected? Because in this system, it's definitely not just anyone receiving a random summons in the mail.
Actually, the texts outline incredibly rigorous qualifications. To be a juror, you generally have to be between 21 and 80 years old. You must be a landowner, that the sources uniquely note that simply claiming ownership of your own bodily estate, your physical self, actually qualifies you. Crucially, you've got to be a publicly declared American, which these documents call a state national or state citizen. But here is the real kicker. The documents insist on absolutely no dual citizenship. A prospective juror must completely forswear all foreign allegiances. And fascinatingly, this includes what the sources term U.S. citizenship, because they view the federal corporation as a foreign entity to the sovereign states.
Check out the stark visual separation between these jurisdictions. On one side, you've got the Union of States acting on national soil, inhabited by state nationals who are private people using the common law. Then, on the flip side, we have the Federation of States operating in international land and sea jurisdictions, inhabited by state citizens running lawful state government. Grand jurors are pulled exclusively from these very specific pools of people who have officially claimed this exact political status.
All right, let's head into Part 3. Grand jury independence.
Now, this is where the sources make their most aggressive claims about accountability and oversight. According to this framework, the grand jury is practically a hidden fourth branch of government. Except, as the sources emphatically point out, it isn't government at all. It's the people. It's not an extension of the state's prosecutorial powers. It doesn't belong to the executive, the legislative, or the judicial branch. Instead, it perpetually exists as a supreme investigative law enforcement body, accountable only to the people. serving as literally the ultimate safeguard against government overreach.
And to back this up, the sources lean heavily on a 1992 quote from Supreme Court Justice Antonin Scalia in the case U.S. v. Williams. Scalia noted that the grand jury's functional independence from the judicial branch is evident in its power to investigate. Within the context of our sources, this quote is held up as absolute, bulletproof evidence that a judge cannot control a grand jury, cannot dismiss it, and definitely cannot dictate what it investigates.
Next up is Part 4, Investigations and Precedents.
So how do these sources describe the actual day-to-day mechanics of a grand jury reviewing evidence and issuing findings? Well, the mechanics they describe are incredibly powerful. First, the grand jury acts as the primary receiver of citizen complaints, basically listening to the grievances of the people. Then, the texts claim a grand jury doesn't even need a specific case brought to them by a prosecutor. They can kick off an investigation merely on the suspicion that a law is being broken, or even just to make sure it's not. Second, they can subpoena records and compel witness testimony without any actual criminal charges being filed. And third, after thorough evidence review, they issue their findings. They issue presentments against state nationals or indictments against foreign citizens, determining if there is sufficient cause for further prosecution. It's a massive amount of authority.
Let's look at a historical case study they use for grassroots accountability. Citing the 1906 case, Hale v. Henkel, the sources argue that citizens can form grand juries entirely on their own. In their reading of this precedent, a grand jury initiated an investigation into corporate corruption, subpoenaed an executive, and when he refused to comply because there were no formal charges, the grand jury just had him held in contempt. When he appealed to a judge, the judge allegedly ruled he couldn't intervene because the grand jury held superior authority. The sources use this story to prove grand juries need absolutely no permission to act.
That brings us to our final section, Part 5, Trial Juries and Nullification.
Let's look at the relationship between grand juries and trial juries. While they share a common foundation, their operational roles in this alternative system are totally distinct. The grand jury is positioned as the supreme investigative body. They are the ones kicking down the doors of corruption to gather evidence. But the trial jury? They sit at the very end of the process. In this system, a state trial jury doesn't just listen to the facts to see if a rule was broken. No, they are explicitly granted the authority to judge both the facts and the law itself.
And this all culminates in the massive concept of jury nullification. Through this mechanism, the trial jury acts as the final check on legislative power. If the government tries to enforce a statutory law that the jury finds morally wrong, unjust, or just straight up repugnant to the common law, the jury can vote not guilty. And according to the sources, doing so doesn't just free the defendant, it effectively voids the statute entirely, setting a new common law precedent. So together, the independently investigating grand jury and the nullifying trial jury form what the sources view as the absolute ultimate shields of freedom.
Well, we've covered the historical timelines these sources rely on, the highly specific juror qualifications they demand, and the massive investigative powers they believe are just hidden in plain sight. As you digest how this alternative worldview structures the balance of power between the state and the people, and as you evaluate these claims for yourself, I'll leave you with this core summary of their perspective. The grand jury serves as the investigative body responsible for reviewing evidence and determining whether further action is warranted. But it leaves us with a huge question. In a modern society built on complex statutory laws, could handing supreme investigative power directly back to unincorporated citizens be the ultimate safeguard of liberty, or is it just a recipe for vigilante chaos? Let that sink in.